develop strong working relationships with accountancy professionals and their clients so that his clients' range extends from small to large, with high net worth individuals, companies who require corporate employee benefit schemes to be established and administered, as well as advice and financial planning for UK and non-UK domiciles and trust. Key areas of work involve investment management, estate planning, pension analyst, occupational and personal arrangements, along with thoughtful interaction of this planning with other tax strategies. He's a member of the Chartered Institute and of Personal Finance. Outside of business, he likes to play most sports, including football, cycling and swimming, and tries to keep up with his 20-something sons, much to the amusements of his long-suffering wife. So we've got a stellar lineup of experts tonight. So if you just go on to the next slide, Sandra. And our first speaker will be Fudia, who's going to be talking about the legal side of IR35 and employment and self-employed status.
Hello everyone, good evening. I hope you can all hear me. As the usual kind of Zoom issues, so just let me know if for any reason I freeze or you can't hear me at all. Also, Sandra, will I be able to move the slides or will you be moving them? I'm not sure.
I'll do. I'm not sure. Yeah, I'll do.
Okay.
Yeah.
Thank you. Thank you. Always best to limit the likelihood of making a mistake. So I'll just wait for the first slide to come up. And just to warn you, I'm hiding in my bedroom because I have a very active toddler who's taking over my usual office space. So I'm just waiting for the first slide.
It should be there. It's on my screen.
I've got a bit of a delay, perhaps. I'm not seeing anything. Just wait a second. Otherwise, I will look at it on a different screen so we can progress. Well, anyway, it's always best to first start with introductions. As mentioned, I'm a partner, and although I'm an employment lawyer, IR35 is one of those issues that straddles tax and employment, which is why Joseph and I have discussed some of these issues last year, or most of these issues, because it's an issue that many are having to deal with. Oh, that's wonderful. And it's finally come up on my screen. In a nutshell, the whole reason why we have this focus on IR35 and changing the rules is because there were concerns of widespread tax avoidance. So the IR35 rules have been in place for some time, and really they provide a mechanism for basically those who are contractors working for a client to have to determine their employment status, that but for them being a contractor, perhaps using an agency to work for a client, would they be an employee of the end user? And as I'm sure most people are very honest when it comes to paying their taxes, but when it's been left in the decision-making power of the actual consultant, the actual contractor, surprise, surprise, most people have said, no, I've done the test and I'm not an employee, I am self-employed, and it's because that has tax benefits. And in light of this, in 2017, the government implemented changes to the IR35 rules for the public sector, which made the decision having to be the end user. And as soon as that happened, everybody was saying, well, it's only a matter of time before that becomes the status quo for the private sector. And again, doing my best Mystic Meg impersonation, they then decided a few years later that they were going to implement it to the private sector. those changes were meant to take place in April 2020. However, unless you've literally been in a coma or hiding under a rock, you will know that last year we've been rocked, and we're still being rocked by the COVID-19 pandemic. And the government, I think, in its wisdom, decided that we were all dealing with way too many issues to also have to contend with this new change. And we'll talk about some of the requirements as part of this change, but they are more onerous than the previous arrangement. And so I think, I'm not sure if I can see it on this slide, but it was on the one I sent earlier. I slightly amended the slides I sent to Sandra, and it said April 2021 was, you know, is this the year when we're actually going to see the rules implemented? Now, as a matter of kind of transparency, it's my view that the government should delay introduction of these new rules. And yet, Sandra, please feel free to go to the next slide. They should delay this because I do think it is going to set the cat amongst the pigeons when we already have a weakened economy in light of the pandemic, and we are starting to see the effects of Brexit. And I'm not going to go down that rabbit hole of people's thoughts on it, but either way, we've already got enough shocks to our economic system. Personally, it doesn't feel sensible for us to make these changes now, but I suspect that the revenue will want as much money into the public coffers, and that's one of the reasons they want to bring this change in now, for fear that contractors haven't been paying the appropriate tax. So that's enough of me waxing lyrical about how I feel about the rules. What are the key questions? So as an employment lawyer, we often deal with employment status, and it's relevant in the IR35 because, again, as I said before, it straddles both employment and tax. But it's worth noting that there are different legal tests from the employment law perspective and from the tax perspective as determining who is an employee and who is self-employed. And the key question is, would the worker have been an employee for tax purposes but for the arrangement? So as I mentioned earlier, you often hear the terminology of disguised employment used in reference to the IR35 situation. And, you know, I know my husband worked in banks, and for a long time they had colleagues who were in the bank for a long time doing similar work for years, but they were self-employed. And as an employment lawyer, I was like, this is, you know, how can that be? How can it be deemed that, irrespective of what the contract states, they are not an employee? And so the type of things that were relevant there is that these individuals had become part and parcel of the organisation, working alongside my husband, but because they were engaged by an agency that then placed them in the bank, they weren't deemed to be an employee, save for these IR35 rules, which they got to determine, having done the calculation themselves, whether or not the employment test is met. Under the IR35 rules, the focus is on determining status for tax purposes, but as I kind of alluded to earlier, it does have wider ramifications. And the reason for that is such: if you do this test and you realise that somebody would be an employee but for the arrangement, sometimes there have been cases where such individuals have sought to go kind of pierce the veil of the contract by saying it doesn't reflect the commercial realities. A lot of those cases have been unsuccessful. There's lots of cases of agency workers trying to argue they were employees of the actual end user, but it does potentially create some kind of complications. And the reason that this matters is because we've seen, and that's a Supreme Court case, AutoCleanse, a situation where HMRC determined that a group of individuals, and they were kind of car valets, were self-employed. But when they brought their claims to the employment tribunals, it was held that they were in fact employees and therefore entitled to the greatest protection in law. Now, I'm not 100% sure about the status of the CEST tool, and I know that Joseph and probably Andrew will be better equipped to say, is it fit for purpose now? When the private sector changes came in, that it was a bit computer says yes, and it didn't. It just kept giving the same answer irrespective of the information you were plugging in. But it's really important that those kind of tools are functional, because lots of people who won't pay for an accountant will be using it to determine their status, to try and justify why they say tax isn't due. Now, the reason that's also relevant, because albeit that the decision as to who determines your status as a contractor / consultant is shifting from the actual consultant to the end user, there is a need for the end user to take reasonable care in providing their determination as to status on why they think the person is either an employee or self-employed. So that test will be useful. And these are a few things, thank you Sandra, that was very helpful actually, that the HMRC guidance will take into consideration when looking at, but for this arrangement with this person being an employee. Now the first three are the same that you would find in the employment tests. And only for the geeks of the crowd, we refer to them as being the irreducible minimum, i.e. you have to provide the personal service, you can't really provide a substitute. Mutuality of obligation and control. Now I've got substitution down on its own because what we have found is over the years lots of employers had substitution clauses in the contract, but in practice the consultant was never allowed to provide a substitute, and so the courts, and I'm sure the HMRC tribunals, will look carefully to see whether those clauses are actually ever exercised. Provision of equipment, risk, opportunity to make profit, the length of the engagement, and this goes back to the example I gave earlier of my husband's colleagues. Some have been there for 10 years. It's far harder to say somebody's self-employed, taking all the risk of self-employment if they've pretty much got a steady gig for a number of years. And how much are they part and parcel of the organisation? As much as I'm going to sound very mean-spirited, where you have consultants who are attending Christmas parties, being appraised, going to Go Ape as part of a team building exercise, it's far harder to say that they are truly self-employed. What other kind of benefits are provided, the length of the notice provisions and how you terminate, what both parties understood the intention behind the agreement was, and other personal factors. Now, from an employment law perspective, the IR35 changes provide an opportunity for a good audit. When you're looking at your staff as an employer, if you have been using a contractor steadily for a significant period of time, and you look through those factors I mentioned in the previous slide, how do they fare? Do they look more like an employee but for this arrangement or not? Before April comes along, and despite COVID, I don't know if everybody else has experienced this, long days, interminable days sometimes, very short weeks. April will be among us before we know it. And the key question there, that employers should be thinking about is, if you want to retain this person, but you're no longer comfortable to have them in this arrangement, because you'll have to make that determination, and the fee you pay will have to deduct NI and tax from their payments, you may want to consider, do we want to bring them in from the cold? Do we want to make them a fixed term or permanent employee? Could they be part-time? Could we hire them under a 0-hour contract? So these are just different ways of saying, if we're not comfortable with this whole arrangement, and because of the rules relating to it, HMRC will get their pound of flesh from someone. So if you're not comfortable with that, how could you employ them? Now, 0 hours may be very attractive because, rather than having to terminate, if you haven't got enough work, you simply wouldn't have to provide them with work. You also have to take into account if they are likely to be employees, and let's say you did hire them, workers and employees are entitled to holiday pay under English law. Now, I promise this may be my second reference and perhaps last to Brexit, but there has been a lot of talk about whether or not worker rights would be reviewed by the government. So who knows what these rules could be, but for the short term, at least for the foreseeable future, that holiday pay is a consideration that you'd have to take into account. In addition, when you make somebody an employee, they earn a qualifying amount, but isn't much. I think it's like £8,000 or £9,000. You have to provide pension payments unless they opt out. And there are other hosts of employment rights, unfair dismissal being the key one after 2 years of service, and discrimination and whistleblowing rights being from day one. Now, again, the reason why this is relevant is if this person has pretty much been an employee throughout, and you do this test and then you decide to terminate them, sometimes people do try and argue, well, for all intents and purposes, I've been an employee throughout, and therefore you owe me unfair dismissal payments for unfairly dismissing me. I mention that simply for the sake of completeness, that employers need to, if you want to take action, you need to kind of be doing this audit now so that you can bear in mind what potential risks there could be for you if you wanted to hire this person, and also if you didn't want to hire them. The apprenticeship levy also, like depending on size, etc., that may apply. So where next? These slides were predominantly produced for 2020 audience, when we thought that the world was going to continue ad infinitum, and the pandemic has kind of turned everything upside down. Previously, self-employment was growing at a rate of knots, was showing no signs of abating. I don't know whether post-pandemic, if we ever get to that stage, people will be thinking, actually, I want to be an employee, because, if any of you have been reading about those who didn't qualify for furlough or for the support schemes available for self-employed, i.e. had, in their first year business, people who'd arranged their payments by making sure they got more paid by dividends as opposed to a salary, etc. And so I don't know whether this is going to continue, but the IR35 changes, in addition to everything else, may have a chilling effect on people wanting to be self-employed, because the whole reason that self-employment has been attractive for people is the tax advantage. If now you get a long-standing assignment and the end user, who has no skin in the game, they don't have to pay any more money, and once they make the determination, so long as they act reasonably, they're not at risk of any kind of legal ramifications, are perhaps more likely to say, yes, we think this person's an employee than not. And if you're then having to pay tax and NI, but you have none of the protections in law as an employee has, family-friendly rights like maternity leave and pay, redundancy pay, etc., it begs the question, why would you still want to be self-employed? Now, in 2018-2019, the chair of the RSA, Royal Society of Arts, Matthew Taylor, did a review and suggested the creation of this new kind of dependent contractor, which is a bit of a hybrid of a self-employed and a worker status, where they would have some, but not all of the rights currently available to workers and employees. Now, I should make clear, you'll hear me constantly referring to employees, workers and self-employed. From the employment perspective, and bless you to whoever that was, we have these three strands, and it's easier to understand them by saying you're either an employee who has the greatest protection in law, but also the greatest obligations, or you're self-employed where you have the least protection, but the greatest freedom. And by virtue of statute, we then created this middle position known as worker, where they have some but not all of the rights of employees, i.e. an entitlement to national minimum wage and holiday pay. And I think once we get through the pandemic and Brexit calms down, it may be that we relook at this to say that unless everyone's now going to become employees, which is not attractive to a lot of people who are self-employed. And I should say, putting my own hand up, having been self-employed for the 18 months, I don't know if I can go back to employment. And so, but we need a position where they have greater protection. And the reason why I go back to the central theme of today of defunct, deferred or delivered is that I think now is the wrong time for this change, because we have so much up in the air and our economy doesn't need any further shocks. And what I fear is that either when the rules do finally come in, there will be a big rush to have people become employees, or those who are self-employed will simply say, I don't want to work in this type of way. Either I want to be genuinely self-employed doing lots of projects, or I want to be just out of this arrangement because I can't see where I get the benefit if I'm paying tax and I don't have employment rights. Now, I know that's a lot of information, and I don't know what the timing is on questions, Sandra. As you know, I have the difficulty of childcare, but if people want me to take questions now, I'd be more than willing.
Oh, sorry, I was talking to myself. So there are two ways of asking a question, either the chat box or raise your hand and you can speak to Fudia. I see there's one hand up, but I can't see whose hand it is. But
It's Amanda.
Sorry, Ian, it's me.
It's me.
okay,
Thank
go
you.
ahead, Amanda.
Hi, Fudia. Thank you so much for that insight into the employment status. So the question I have is that, so I work for a virtual legal practice, and we actually employ contract lawyers. So all of our lawyers are on contract, and they're either trading through their own limited companies or they're trading just as their individual selves. And then, of course, we feed out to a vast number of our business clients. So where does my concern is the IR35 liability that my virtual law firm has in respect of our own consultant lawyers?
I can understand that, and thank you, Amanda. That's a great question. I mean, the first thing I would say is, how do they work in practice? When you place these contract lawyers with a client, are they presented as being part of that firm? Do they only work for that firm? Do they have to work set hours, etc.?
No, so what happens is that any of the end user clients come in centrally into the admin for the virtual law firm. The admin then allocates the work accordingly. So some of the consultants will be dedicated and only work for us. It depends on their own work-life balance. Some of them will have, their own direct clients, or indeed other law firms that they contract into.
So if you were to look back at that employment status guidance page I had, I don't know if the slides will be made available, but I would almost use it as a checklist. And I know from having heard Andrew and Joseph's talk last year that they will also touch upon this. But really, it's about ensuring that these individuals don't hit these tests. So, for example, mutuality of obligation. Do they have to do the work that's offered to them, or can they say, I'll pick this assignment, won't pick that assignment, etc.? The former makes it the argument that isn't in existence. The latter would suggest that they're not going to be an employee. Can they provide a substitute, a suitably qualified substitute, to do the work? Again, that's a good key to saying, look, personal service is like the bedrock for employment status. And if the fact that I can provide whoever, that's going to help. In the sake of transparency, I work for one of these new style law firms called Spencer West, which is a bit like, the Keystones and the Gunner Cook, where we're all self-employed and we do the work that we want to do. And I choose what hours I want to do. I choose what cases I do, etc. It'd be very hard for HMRC to argue that I am an employee, because my contract makes clear I can provide a substitute. And again, I'm due to have a baby in a few months, so I may very well have to provide a substitute. I don't have to take on any work that I don't want to. My firm don't tell me how, where, when to do the work, other than the regulatory requirements on me to, store things centrally, file reviews, etc. I had to provide my own laptop, my own phone. The risk I have is that if I don't accept work and I'm like, no, I don't get out of bed for anything less than this, I may end up having no money. Yes. But I also have the opportunity to profit. And, it's all of these things that help to show that these people who are working for you are genuinely self-employed. And so when they are placed with a client, one of the things I remember Andrew talking about at great length last year was examining the length of an engagement. If you have somebody who's in a place for several months working on one big matter where they're kind of becoming part and parcel of the team, it becomes far harder to distinguish them. And if they're the only ones who do the work, and your client's always saying, oh, because they're so great at IP, then we've got this big IP case, etc., that's where it can become difficult. So I think really to try to avoid IR35 from biting is going to require parties to sit down and think purposely about, how is this engagement going to work in practice? How long does it have to be? You know, rather than having, you know, open-ended contracts, we're recommending people have, you know, kind of like statements of works, almost like this is agreed work for this particular project. You know, making sure that sometimes you mix clients and mix the individuals who are working so that they don't become part and parcel. So what I would say is that I wouldn't fret. I think particularly with the way that law firms are operating now in this kind of modern environment, it's more a question of really thinking about how you structure these arrangements so that IR35 doesn't bite. Does that answer your question, Amanda?
Yeah, that's really helpful. Thank you so much, and congratulations on your pregnancy.
Thank you so much.
Can I just add that there's also the risk that your lawyers become classed as employees of your clients if they're on like a long-term assignment, can't they, as well? That's the other risk, I should imagine.
Yeah. So I think that's a really good point, Ian. And one thing I perhaps didn't specify, you obviously need to be concerned about them not being your employees.
Yes.
And also them not being the employees of the ultimate end user. Yes. Because the test is whoever is the end user is the one who's going to determine status. But you, as your role of fee payer, will just be the one executing the actual PAYE.
No, thank you. Appreciate that.
Good, thank you, Amanda. That's a really good question.
Thank you.
Are there any more questions for Amanda? For Fudia, sorry.
I don't mind if Amanda answers them.
It really wouldn't be very helpful.
Right. There aren't any at the moment, so Fudia, if you want to go back to your 2-year-old.
I will try and pop on later if I can. If not, if people want to send kind of collate questions, I'd be more than happy to try and answer any. But I know that I'm leaving you in the very capable hands of Andrew, Joseph and Mark.
Right, thank you so much.
Thank you.
See you later. Thank
Bye.
you. So now I'm going to, we've got Joseph Brown, who's a tax expert, and Joseph, would you like to take over? And the slides will be changed by Sandra.
Okay, well, we'll wait. Thank you very much, Ian, and good evening to everybody. I don't know if you can actually hear me clearly. Can you all hear me clearly?
I can, thank you.
All right, let's hope that everyone else can as well.
We can hear you, Joe, but we can't see you.
Oh, right. Well,
that's a shame. That's a shame because you're a handsome chap.
Flattery will get you nowhere. Whilst we're actually getting the slides, here I am. There we are. There's a little bit of me. But I know that we're going to be having the slides coming on very shortly. I have to sort of continue with some of the thoughts that Fudia has, and while the slides are coming on, I do actually sort of agree that we're in a very delicate time, and when we last met in February 2020, when we met in February 2020, we had the issue of discussing the advent of IR35 in relation to the new payrolling rules. And I do recall actually having a chat either with Ian or Andrew, and basically stated at the time that I didn't believe that we would have the new rules coming in from the 6th of April 2020. It turns out that I was proven right. Since we last met, obviously we've had the pandemic and a number of other things have actually sort of developed. But a couple of issues have come about, in particular, where we have seen firstly, the off-payroll rules actually been enacted in July, and yes, it has actually undergone some sort of scrutiny in the House of Commons and the House of Lords, and then sort of finally enacted in July, and in my mind, even though I would like to think that we will have a deferral of IR35 for the private sector, the mere fact that we've got this enactment in itself will actually sort of push it through, even though I feel that the law behind IR35 is still faulty. It was faulty back in February 20, and I still believe it is faulty now. So the changes that we have seen since July 20 has actually extended to some assurances that HMRC will not use information that they may have previously obtained to check whether IR35 applies to, to previous years, and which means that seems to sort of give individuals a crumb of comfort that anything that is actually sort of generated, any sort of contracts that is generated up to 5th April 2021 should not be attacked, but it does then sort of raise the question of if that contract breaches the 5th of April 21, whether or not then that contract then would fall within the new rules, and whether or not the revenue would then sort of lessen their views in relation to taking issue or umbrage in relation to the operation of that particular contract, that it has been in existence possibly for a number of years, and then has sort of breached the 5th of April 2021. It's an interesting question, but nevertheless, it's something that we may well have to be careful of, and as a result of which, it is something that we need to sort of really consider going forward. Well, some of the other small changes is that there's a new template for businesses to use when responding to a worker if he or she finds that the IR35 rules apply, and then there's some further guidance and explanations in relation to the businesses that have decided that IR35 applies, and to the service provider, and then instructions in relation to PAYE calculations. And then the further guidance, which generally speaking doesn't really apply to many of the contractors, is in relation to how the new rules will apply in relation to statutory payments, and whether or not and just look at the interaction between IR35 and the construction industry, or the CIS rules, which obviously can be quite technical, and so therefore the revenues guidance is there. I still believe in my own heart of hearts that the changes are not sufficient enough, and we may find ourselves, and this is just a personal opinion, but we may find ourselves back to where we were in 2001, where we found ourselves actually having the same situation where the end user, the client, was effectively determining the status of the contractor, and then finding themselves, or the revenue then sort of succumbing to a number of appeals or complaints made by some of the larger companies in the country, and then they push it where the responsibility is actually on the contractor. The truth be known, we may well go down that route, and it is an interesting time that we're in, because it is almost a bit of a limbo, because lots of things may well materialize between now and the 5th of April. But what's clear is that there is a significant hole in the purse of the country, and Mr. Sunak has got to plug it, or at least to try and attempt to fill it. And we can clearly see that this year, as any sort of tax advisor will probably see, with the amount of money that has been flowing out in relation to furlough and to a number of other benefits to help individuals during the pandemic, that we're actually then going to see a significant tax raising event come next month in the budget. And so therefore, I think you know it is up in the air, but I do believe it's swinging towards we as being subject to significant tax penalties as a result of the pandemic. Next slide, please. Well, these slides were from last year when we believed that IR35 was going to be coming in, and one of the thoughts that we had was the only way that we could see ourselves getting out of the IR35 net is to try to avoid the situation for the contractor and the end client, or the representative of the end client, sitting down together and constructing something that is good on paper, but then at the same time is complemented in reality, and so therefore there's got to be a leeway, and we all appreciate the fact that most clients like to dictate to their contractors, but the essence that we're trying to highlight is the fact that a truly self-employed individual offers a service to his client, as opposed to the client telling the self-employed individual what to do. And we're talking about control. It will be helpful if, you know, it can always avoid replacing an employee that had been carrying out the duties for a number of years, because then that in itself, the revenue would take an issue with that and will say to themselves, well, if that individual had been sort of an employee for many years, yes, we may well have terminated his employment, then what about the individual that is coming in now to replace that individual? And so the big questions arise. Fudia touched on the aspect of the substitution, and my view on that is that anybody could put in a substitution clause, but I think it's absolutely vital that if the individual is going to have a potential substitute, then they have an adequate individual, they introduce themselves, introduce them to the end client or the representatives of the end client, even though they may not actually use them at some particular point, but nevertheless, it's actually important that they are aware, and ideally, if the name of that individual or names of the individuals can be outlined in that contract, then that will be ideal, because then it sort of makes the potential for using those individuals as being very helpful. Now, I'm just trying to, there's two more points at the bottom there, which I'm just struggling to find, because they seem to be blocked out by the bar. I don't know if you could see that. If not, then we will just go to the next slide, because they're all there, and then the next slide will actually sort of take out a number of things, because even though we've actually had, you know, the substitution clause, we've talked about control, we've talked about the mutuality of obligations, which, to be honest with you, it is probably one area in relation to the IR35 realm which has very strong opposing views, because the revenue actually take the view that mutuality of obligation is in fact employment, and then the profession then actually sort of argues quite strongly, and there has been a number of lawyers, significant QCs, who have actually sort of said, well, we don't see it like that. So what I do actually believe that there should be is the aspect of financial risk. And if we just exclude things like timesheets with checkshot, and then to sort of introduce every project or every assignment as a project-based activity where if there is a mistake made, then it's going to be repaired by the contractor. He will actually have to spend his own time in doing so. And if you've got a set fee program, obviously, then that actually helps significantly, because then with the extra hours, the extra time, etc., that will be done, there is no overtime, all of which denotes an element of financial risk. Yeah. Invest in your own equipment, making good any work performed in an unsatisfactory manner in your own time and at your own expense, all of which actually sort of again highlights the issue of financial risk. Taking out professional indemnity insurance, which again would be able to sort of help in whatever situation that is going on. Looking at the professional training and trying the utmost to sort of avoid being a fixture in the office. And actually, one of the worst things that you can actually sort of do is you being a contractor and you're there, and then you get a business card and you hand it to you know, one of your clients, and you're referring to yourself not as even as a contractor, but as some sort of director. Now, from my perspective, a director suggests that you're an employee. And I've seen this in the past before, and so therefore the things that we should be doing is to try and avoid anything that suggests that you may well actually have a fixed status with the company that the contractor is working for. Let's go into the next slide, please. Right, well, as we have said, IR35 or this new style payrolling arrangement is very much stringent than anything that we've had before. And if the truth be known, many contractors have benefited from the revenue, probably not being able to inquire in great depth into their affairs. Yes, we can see that inquiries have increased over the years since 2001, when there was very limited inquiries, and the last figures that I saw was that there were roughly about 20,000 a year of inquiries, rising from just only 2,000. So we could see that the revenue, the Treasury, sorry, has actually sort of directed the revenue to look at and look closely at the issues that many of the clients will actually have. Employment agencies do actually have an obligation to advise HMRC of the situation, and it is actually very, very interesting because we have got numerous individuals working for substantial banks, and I had one particular individual who was actually earning a lot of money with one particular bank, and he was clearly an employee. And in his defense, he came to us actually sort of asking, well, I can't sleep at night, and saying, well, you know, what do I do next? And we said to him, well, do you realize what you're actually asking? And he said yes. And we actually undertook a review from it. And there was no question of it that he was in fact an employee. And then we went to the revenue and disclosed everything with his consent. And it actually sort of turned out to be quite useful for him. And i.e. in that, yes, he did have to pay some money, but not as much as he thought. And we were able to use some of the taxes that have been paid in relation to corporation tax to be used as a credit against any income tax liability that was arose. And that was only because of the fact that we had actually gone to the revenue with our hands held high and asking for mercy or leniency. If in the situation that we find ourselves in, I'm almost certain that if the revenue raises an inquiry and they establish that that individual should not have been self-employed, then that will be, as far as I'm concerned, a very dark and difficult time for that particular employee. And the benefits that I have seen, or we have seen, in coming forward may not actually be available should there be a determination that the individual is not in fact self-employed, but in fact employed. And so it can be a very difficult time. So as we look at the options that are available to us, and there's not many, to be honest with you. Well, the first thing that I would do is just to sort of make sure that the client or the representative of the client in discussions with the contractor is has got all the facts that are available in relation to the appointment. And it may actually be possible that, as I've actually seen some banks, and what they're doing is that they're giving a blanket status determination statement stating that the individual is an employee, and not in fact looking at the actual activity of the individual, whether there is control, whether there is any sort of risk involved, and so therefore it certainly is worth the individual, whether he gets that employment status statement, going back and checking to see whether or not that position could be altered. I would, in a situation like this, consider paying a salary, because I mean the norm has been that most individuals would actually sort of take a small salary, and then the balance will be in the form of dividends. I'm not too sure whether or not that would actually be helpful going forward if that person was actually in an employed state. I would suggest that to try and limit the problems that could arise, that they consider paying a significant salary each year instead of the small salary and large dividend option. One thought that came to me was, well, what about setting up a company pension scheme? Because obviously that seems to be the afterthought for many contractors. Why? Because, you know, they have benefited so much by virtue of having a small salary, making use of their personal allowances, which just about, you know, covers, and they pay a limited amount of maybe national insurance and employers' national insurance, and then they take the bulk of their extracted funds in the form of a dividend, which in some respects is probably not helpful. And my thoughts then sort of went on to, well, if you're not taking making a large enough salary payment to yourself, then that would probably mean then that you know, there is issues with regard to is there relevant earnings? And so the idea is to consider sort of making salary payments to actually have relevant earnings, which could then sort of enable you to have the benefit of annual pension allowances that may be due. The relevant earnings, obviously, let me just go back and say that they are small because they would only be equal to personal allowances, but depending on the level of salary that is actually paid, then it's possible that we could actually use some of the unused pension relief that for the previous 3 years, and look at making a significant salary payment, say for argument's sake in the 21-22 tax year, and then using some of the funds that may well have been accumulated over the years, which is just sitting there, and using that to invest into a company pension scheme, etc. This is only a short-term temporary role, but it is certainly something to consider, and especially as the fact that if you are taking out significant dividends out of the company, then there's not really going to be much of an opportunity for you to build up a sizable pension fund. So it's just a thought. The final point, which at the time I didn't particularly like in February 2020, but I'm going to highlight it again because it could well be an option for someone, is have they decided then to sort of give up being a contractor? And if so, is their contract going to cease before 5th April 2021? And if so, then that will be probably an ideal time to consider sort of liquidating the company, actually having the company enter into members' voluntary liquidation, and then make a distribution to the contractor prior to, ideally, before the 5th of April 2021, or it can be probably after, as long as the appointment has been made pre 6th of April 21. Now, the issue here is that the distribution that could be made will obviously be subject to entrepreneur relief, because it will actually be treated as a capital disposal. We've got entrepreneur relief, although sort of significantly reduced from 10 million to 1 million. It still actually sort of makes a lot of sense, and that the actual effective capital gains tax rate would only be 20, or would be 10%, and which would then sort of give a large amount of funds available for the individual to do as he pleases. It's just one way of just trying to extract funds out of the company. I have looked at what I believe to be those areas. I've tried to sort of go further and deeper, and at this present moment, I don't immediately see any way around where we could actually sort of minimize the PAYE stroke national insurance aspect, unless you've got either a pension scheme or sort of a pension scheme with pension funds or monies going into the scheme, or indeed probably terminating or liquidating the company in sufficient time, and to actually have a capital extraction out of the company.
Well, thanks, Joseph. We're running rather late, so sorry.
I'm done. Thank you.
Thank you. So we'll have Andrew and Mark, because I have a deadline to leave at 15:15. So, but that can continue after I've left. So, Andrew, would you like to talk?
Yes, Ian, I've got a hard stop at 7:15, unfortunately, as well. So I will whiz through what I will talk about. But I guess time flies by when you're having fun.
Yeah.
Sorry.
That's all right. No, it was very good, Joseph. Do you want to start, Andrew? I'm sure Sandra will change over the slides as you talk.
Yes. So I wanted, again, I presented with Joseph and Fudia last year, and it was a different situation for a whole host of reasons. I go back to Fudia's point around it being deferred again, and Joseph also gave a view. In the past year, I've made a point of making a beeline for contacts within inland revenue, one senior bod in particular, and there is a genuine intent from revenue, which clearly comes from Treasury and government, that this will not be deferred. That said, there are some engagers, being the end client, and equally the fee payer, being the recruitment agency, are sat there, their fingers crossed, praying for the budget, and that there's a deferment. And I think what Joseph talks about around Mr. Sunak spending lots and lots of cash, and we do have to plug that hole. I would agree with that. It's just and also what I found is over the past year, we as Workr Compliance have spoken to more public sector bodies, and there's a genuine realisation that whilst on the 6th of April, technically there'll be parity between the public and private sector, the public sector, the private sector has a habit of being a bit more entrepreneurial and will adapt to the legislation to retain and attract talent, being contractors, freelancers, whereas the public sector may still dwell on certain decisions and what to do going forward, which will present them to be a competitive disadvantage. And I'll be very, very quick. So over the past year, we've had some movement from the revenue. As of today, there's 42 working days to the changes, and I've just come off a webinar before this webinar and talked about that point around 42 working days. What we have seen is that the revenue have issued three key employment status manuals. For me, they're all important, but the two really important ones for me are the basic principles of reasonable care. So as the engager, as the end client, if you're a contractor providing services to an end client, the end client should be doing these four things, if not now, very, very, very soon. Make an IR35 decision, take reasonable care to make it, communicate the decision via an STS and giving the reasons to the relevant parties, and create a client-led disagreement process. So if you go away and read that employment status manual, it's quite clear that's what the expectation from revenue is. And the other as well is the transfer of debt provision. So it's a very, very basic level. From the 6th of April onwards, the transfer of debt provision intermediary one will sit with the fee payer, and that will apply to the fee payer being the recruitment business, where the engager has issued an STS, is being sent to the end client, the fee payer. They are in agreement with the SDS, which then release the gross funds to the PSC. So it's releasing of those funds to the PSC being gross that triggers that liability for the agency. So we're seeing a lot of discussion around how recruitment businesses can manage that liability. Market observations, we know that there are some engagers that are unprepared. I'll let you read it, but for me, it just provides too much uncertainty for a contractor level. They want to understand what is it the engager is doing to prepare for reform. They want to understand whether their contract will continue at the current status of through a PSC. if they're deemed to be inside, what are the options if they want to stay? If I'm not being informed of what the end client is doing to prepare, do I terminate, serve notice on my contracts and leave? So there's a lot of uncertainty at a contractor level, which I really do feel for. Equally, there are some engagers that are very well prepared, and that will provide improved certainty at a contractor level. So they understand how to meet reasonable care. They're involving the recruitment agencies in their project delivery and methodology and getting prepared for the 6th of April. The last point on this slide is that over the past 3 or 4 months, I've noticed a lot more marketing collateral, webinars, discussions around IR35 tax investigation and lost products. And what we have now is a choice in the market. What I am also seeing is that there is a vary in the terms of the policyholder. There are 2 insurance brokers that sell to recruitment agencies that are asking the director of the PSC to take out the insurance, which if you go and read the legislation, and I'm sure lots of people have, and Joseph has, within the legislation, there is no responsibility nor liability on the director of the PSC if they're providing their services to a medium or large end client. So for me, I find it problematic that if I'm a limited company contractor, I'm being asked to take out the insurance to provide the indemnification. What should be happening is that the fee payer, the recruitment agency, should be seeking to take out insurance if they wish. Last point, you can either get access to a standard vanilla insurance product, standard policy, standard pricing, standard renewal, or you can look at a bespoke policy to manage the tax risk. Not for now, because we're moving on swiftly. It'd be good to get Joseph's view on another session, but there's potential MSC risk on that standardised tax investigation and loss policy for a fee payer. What should engagers and fee payers be doing with 42 working days to go? And again, this is for contractors that are providing services to an end client through an agency. As a minimum, they need to be aware of the changes. They should be engaging with the fee payer supply chain to review it, chosen methodology and agree and implement it, and risk profile of the impact to operational delivery. So going back to my first slide, I put some logos of some of our customers, such as Worley, IPSL, Veolia, Store, Petrofac. They use thousands and thousands of contractors. And what they're very mindful of is we need to do this piece of work to prepare. We need to do another chunk of work to prepare for IR35 BAU, ready for enforcement, but we've still got the operational delivery of our businesses, the day job that we need these contractors for. So it's very, very trying times for some engagers. In an ideal position, engagers should be doing all the above, but also starting to issue status determination statements. They should also be considering the alternative pay options for contractors that are deemed to be inside the scope of IR35. And in the market, we are now seeing more discussion around compliant umbrella services to that of agency PAYE. And Fudia talked about it earlier. As an agency PAYE, I'm engaged as a worker with minimal rights. As an umbrella, I'm engaged as an employee. So again, that's going to be quite a topical point for contractors going forward. Move on.
Right.
Nearly finished. I'll let you read this, but this is just an overview of our methodology within Workr Compliance. And just before COVID, we were close to 4,000 status determinations. We follow a collaborative assessment methodology. What we do differently to others is that we go at a contractor level. We go at HR legal level rather than starting with the contractors. And it's a genuine blend of people, process and technology. Move on, Ian. And that's it. Sorry, mindful of time. That was a whistle stop overview and update from Workr Compliance since we last presented. So thank you all for listening.
Thank you, Andrew. And now Mark, finally, but not least.
So it's a danger when you're right at the end, isn't it? That I think what we'll do is that obviously Mark Wealth Management sponsored the event, so I'll take the hit, and I'll just do a quick 1 minute. Because I'm conscious that you've got to go. and the fact that some may just want to ask a couple of questions because it's quite a substantive subject, isn't it? I'm just picking up on something that Joe mentioned about pensions. You know, obviously, if people are liquidating their businesses, there is a way, obviously, of an employer contribution being made rather than generating a salary, a high salary. Different ways of doing it, and then the carry forward can be done that way using the allowance. So if a company has got to change and become PAYE, the liquidation cost could be quite high, £5,000 for a liquidation, a small company liquidation. So clearly, using the business asset disposal relief or entrepreneur relief, using pension planning as well. That's what Mark Wealth Management does. I work very closely with Joseph and who said the tax specialist. So very happy to assist anybody, any queries, any anxieties over this. Feel free after the end of the seminar. Ian, you've got my details.
Yeah.
And obviously, with Joseph, we can pick up these queries and try and create some reassurance, if anything, because there's a little bit of anxiety there. Andrew's comments were quite. It seems quite finite that it will be happening. So. Leave that with you, Ian. Thank you very much for inviting me.
Yeah, well, what I would say, Mark, is I'm sure you'd be very happy to do a webinar for 30 minutes at another time, so that if anybody's got any interest or questions, then I'm sure you'll be happy to do that, won't you?
Absolutely.
Yeah, well, and thank you, Mark, for sponsoring tonight's event. So before we finish, any brief questions? Otherwise, I'm going to thank all our speakers tonight, to Fudia, to Joseph, to Andrew and Mark. I think it's a very interesting subject. I've been a kind of victim of it, and I think unfortunately a lot of people were moved off their PSEs last year in anticipation of the changes, and lots of multinational companies and banks have actually now stopped contracting through PSEs and now only wants people to be employed in some capacity or not through an umbrella company or through an agency and seconded in. So unfortunately, I think a lot of people have already changed because there were such big changes had to be made to payroll systems that when the government suddenly stopped, sort of suspended it, it was only a few weeks before they were going to bring in the new regulations. So I think there's a lot of controversy there. So anyway, I'm going to thank everyone tonight and thank our speakers again. And we've got another event coming on the 25th of March, which is The Only Way is Ethics. So you can look on our website for details of that event. So thanks everyone for your time and have a good evening.
Thanks, Ian.
Thank you.
Thanks, Andrew. Thanks, Joe.
Thank you.
Thanks, Mark, Andrew, and Ian.
Thanks, Andrew.
Thank you.
Bye-bye now.
Thank you.
Bye.
Thanks very much.
Bye. Bye, Mark.
Bye, Sandra.
We'll sort something out.
Yeah, if anybody has any questions, of course, just provide my details and then I'll take them offline.
Yeah. Yeah, okay, that's fine. And we'll sort something out for April.
Yeah.
Yeah, is that okay?
No problem. Yeah, no problem.
Okay, right. See you soon.
Bye.
Bye.